Welcome to the annual ICLQ lecture. It's really nice to be able to be in this room again. There are times when I thought I would never find myself saying those words, but it really is. Last year, as many of you may know, we held our annual lecture wholly online, and there were many advantages in that. It enabled participation from all around the world. This year, of course, it's wonderful that those of us who can are able to gather here in person together to hear the lecture, but it is also equally wonderful that so many people are now able still to join us from around the world, taking advantage of our newfound familiarity and ease of use of electronic means of participation. So this is very much a hybrid event, and perhaps it is in the nature of the transitions of one thing to another that at the moment still very many people feel more comfortable listening online than in person. This is to be expected, but thank you very much those who are in the room, but thank you also all those people who are joining us online. And once again, I can say I know joining us online from right around the world. I know we have people from who have in the middle of the day or early in the morning in Canada and in other places. But of course, we also know that we have some of our key participants here today who amazingly are joining us from Australia at what I believe is 3 o'clock in the morning. Not only is their commitment to the academic endeavour fully demonstrated by the work that they have done, which is published in the ICLQ, but it is also further demonstrated and reinforced by their willingness to commit to join us at this time, and we are hugely grateful for them for doing that. Let me just explain a few words about how we anticipate the our evening, your very early morning, from playing out today. In a few moments, we will begin by my inviting Rebecca Barber to share a few words with us and to talk to her for a short while about her work and her article. Rebecca is the prize winner of our Early Career Prize, and we are delighted that she is able to join us to share a few words of both congratulation but conversation around her article published last year concerning the General Assembly's relationship with unilateral sanctions. And so we will be hearing more about that in a few moments. After we've spoken to Rebecca, we will then turn to the principal lecture this evening, which is going to be conducted in 2 parts. First of all, the article had co-authors, and Michelle Rourke is going to be starting off the evening, perhaps somewhat unusually also from Australia, and indeed also from Brisbane. And so 2/3 of our evening is live from Brisbane. And then after Michelle has spoken, then Mark will be who's only come all the way he is at King's College and lives up in Staffordshire. Your journey is as nothing to be here this evening. But then Mark will finish off the evening in talk, and then we will have a time for question and discussion arising out of the lecture, and then we can join for some refreshment afterwards. So that is the programmed running of the evening. But just before we start the formalities around this, there is one other thing that I do want to take advantage of this evening's occasion to do. As you know, this is a lecture of the ICLQ. The prize winners are decided by the board of the ICLQ, and I did want to take a few moments this evening at the start of this lecture to give my sincere thanks, of course, to all the members of the board of the ICLQ for the work that they do in supporting the work of the journal, but in particular to make mention of 2 members of the board who are actually leaving us in the coming months. Well, one has just left us, Professor Ian Cram of Leeds University is stepping down after, and I'm not going to say how long they've been members, but from a considerable period of time on the board, and also serving as the book review editor for the journal, having done a fantastic job supporting the book reviewing and the work as a whole. He is unable to be with us this evening, but I know he is planning to be with us online. So I would like to express my many thanks for all the work that has been, that you, Ian, although I can't see you, I know you're out there somewhere, have done on behalf of the journal. One thing I've never quite got used to do is saying goodbye to people from roles, because you never really quite say goodbye. But I do want to thank Ian for what he has done. I also, of course, want to thank one of our other editors who hasn't quite left us yet, but will be leaving us before too very long, who is in the room tonight, Robert McCorkadale. Robert has been not only a long-serving editor and indeed a co-general editor of the ICLQ, he was until some years ago, of course, director of the British Institute, and has played a huge part in the life of the journal, as he has in the Institute and, of course, of international law in this country and beyond. He too is going to be stepping down from his editorial role in a few months' time, and it seemed appropriate to use this lecture to say a few words of thanks, but not only a few words of thanks. Thanks sometimes do need to have some tangible recognition, and so we do have here, I'm not quite sure how I'm going to manage to hand this to Ian, but I do have a card here that will eventually go to Ian. You will notice the very best of cards now look like the ICLQ. These were perfectly produced by Cambridge just for this occasion. And when I said, is this the ideal image for this occasion, they said, what more could retiring editors want than a permanent souvenir of their time with the ICLQ? And so here is one for you, Robert. Thank you. I can also add that it also mentions inside, in good ICLQ fashion, that there will be a gift of £150 worth of ICLQ books from Cambridge University Press. Also, going along with as a tangible demonstration of our thanks, is life membership of the Institute, which you may already have. But some things are, but Ian, you will join as a life member of the Institute. And also, Robert, if you would just move for just a moment, we also have, someone tell me there was a brown plastic bag in here. Yes, there is. Possibly be. We have in here just a little something of a variety and something also.
Oh my goodness.
As a minor token. And for Ian, who is not in the room, when you are able to visit London, the self-same is available for yourself too. So thank you very much. Yeah.
Thank you very much.
And you can have it back. Well, thank you for giving me the opportunity of doing that. And now we will move to Michelle as the early career prize winner. Nothing in this also as a tangible recognition of the prize winner. I believe that there is a prize of £250 worth of Cambridge University books, which is available to the early career prize winner, which I believe has already been communicated to Michelle, as well as Rebecca, as well as a certificate, and that will be on its way. I'm sorry, I'm getting confused about the Brisbane, the online connections. So with that, could I now turn to you, Rebecca, to ask you, you're on the screen, yes you are, thank you, to talk about your article concerning the unilateral sanctions. Could you just start off by telling us what your article is all about, and then we'll take a few questions further from there.
Yeah, thanks so much for having me. I'm sorry I can't be there in person. I did actually try, but unfortunately, my plans were foiled. My article on the General Assembly's relationship with unilateral sanctions seeks to make sense of two seemingly contradictory aspects of the General Assembly's practice. On the one hand, on many occasions in the past, the General Assembly has recommended to states that they impose sanctions. In most cases, the recommendations have been made in the absence of a Security Council mandate for sanctions to be imposed. So the recommendation of the General Assembly has been for unilateral sanctions to be imposed by states. However, on the other hand, since the mid-1960s, the General Assembly has passed resolutions denouncing economic intervention in the affairs of states. And since the mid-1990s, it's passed resolutions explicitly condemning unilateral coercive measures, or in other words, unilateral sanctions, as illegal. So in the practice of the General Assembly, this is quite a conundrum. And from a practical perspective, it poses difficulties if the General Assembly wishes to recommend sanctions in the future. Sanctions are one of the most important tools in the diplomatic toolkit of states, and the General Assembly has a potentially really important role to play in recommending sanctions. But if the General Assembly is to play a role in the future in recommending sanctions, it seems important to understand, particularly if one is to advocate for the Assembly to play such a role, it seems important to understand exactly what sort of measures the General Assembly has previously condemned as illegal. So my article seeks to clarify that by closely examining the General Assembly's resolutions on unilateral coercive measures and understanding precisely what type of measures the General Assembly has actually meant to condemn as illegal.
Thank you. So you've trying to address this, on the face of it, conundrum between the desire to impose sanctions, which seems to be evidenced in practice, but also the reluctance of the General Assembly, or rather the willingness, the urgency with which the General Assembly seeks to condemn unilateral coercive measures. How do things sit between the two? And I suppose it's hardly worth asking, it may seem at the moment, why this is such an important topic. When you wrote your work, and indeed when we published your article, little did we know that the topic of sanctions would be so significant on the global stage, as it has turned out to be. So in the light of current events, would you care to reflect a little bit more on what is so important about your work in relation to this and the light that it sheds upon what can be done here?
So yeah, as you say, current events, and obviously we're talking about Ukraine, have highlighted very clearly that when faced with violations of international law or threats to international peace and security, or atrocity crimes, which is what my research focuses on primarily, the states do not have a vast toolkit full of options available to them, short of the use of force, which everyone is generally trying to avoid, and obviously as is the case at the moment in relation to Ukraine. So sanctions are really one of the most important tools that can be used by states to promote compliance with international law. In some cases, the Security Council imposes sanctions, in which case the role of the General Assembly is not so critical. But in other cases, again, as we're seeing very clearly right now, the Security Council is unable to act due to the veto of one of its permanent members. And in these cases, the General Assembly has a really critical role to play. Of course, states can and do impose unilateral sanctions with or without a General Assembly recommendation, as they're doing right now in relation to Russia and Ukraine. But a carefully worded General Assembly recommendation for sanctions can feasibly achieve a number of things. Firstly, it could feasibly bring about greater consistency and coherence in the sanctions that are in any case being imposed by states. Secondly, it could encourage additional states to come on board, states that may be less willing to come on board without a General Assembly resolution. And thirdly, it could call for sanctions to be imposed in a manner that complies with international law and in a manner that would not be inconsistent with the General Assembly's previous condemnation of unilateral coercive measures. So, for example, a General Assembly recommendation for sanctions could call for sanctions to be imposed in a way that doesn't negatively impact human rights in the targeted state, and where sanctions target individuals, as is increasingly the case now, a General Assembly recommendation could call on sanctions to respect the basic requirements of due process with regards to the targeted individuals.
Well, thank you. And clearly, this is a matter of huge significance at the moment, and much work and interest much work remains to be done in this field. Could you just say how this is going to fit into how you are, I suppose, responding to current challenges, current thinking around this, and how the work that you've done, your article and research is going to fit into your future development and work, and areas that you think are of interest and importance here?
So this article is a chapter in my PhD thesis, which is on the powers of the General Assembly in international law to prevent and respond to atrocity crimes, in particular when the Security Council is paralysed by the veto of one of its permanent members, which is quite frequently the case when in situations in which we are faced with large-scale atrocity crimes. And my thesis considers three broad questions. Firstly, what are the legal powers of the General Assembly in the UN Charter, and how are they to be interpreted, and how have they been interpreted in the past? Secondly, how has the General Assembly acted on those powers in practice, specifically in relation to threats to international peace and security? And thirdly, how can the General Assembly more creatively and constructively act on its powers in relation to atrocity crimes in the future? So this is the broad framing of my research at the moment. In relation to the last question of how the General Assembly can more creatively and constructively act on its powers in the future, I explore three specific things that the General Assembly can do, which I have felt warranted attention, both because they've not been closely examined to date, but also because they can be usefully acted upon in current crises. So those three things that I'm particularly interested in are, firstly, the power of the General Assembly to pass resolutions with what I call a determinative or quasi-judicial effect. Secondly, recommending sanctions, which is this article that we're talking about. And thirdly, the power of the General Assembly to pass resolutions on the legitimacy of governments, which is the subject of my forthcoming article in the ICLQ.
Well, indeed, to pick up on that point, this is an article in the ICLQ. Is it a spoiler alert? Hardly a spoiler alert to say I think you have yet another article which we are looking forward to publishing from you very, very soon. And I'm sure we'll all look forward to that. So what are your plans for the future?
So the next thing is this article, and I'm actually engaged in with a few other colleagues in some advocacy on this at the moment. The article considers the role of the General Assembly's credentials process in determining which authority should be entitled to represent a state in the General Assembly. And it also considers whether the General Assembly can play a role beyond the credentials process and pass a resolution which would provide guidance to both states and international organisations on the question of which authority should be regarded as the legitimate representative of a state. And it's an issue that's particularly relevant to Myanmar right now. We see a situation in which Myanmar is represented at the International Court of Justice by the military junta and excluded from the Human Rights Council altogether due to the relevant decision makers not wanting to have to make a decision regarding who should be entitled to represent Myanmar. So that's a particular focus for me at the moment. beyond that, really, I'm in the process of wrapping up my PhD thesis, and I suppose at some point may turn that into a book when we get to the next step.
Well, that's quite a large agenda of things to be doing, at the moment. And it's just so good to, see work of this stimulation and quality being produced. And it's so exciting to have the opportunity of publishing your work in the ICLQ. And just we're really grateful, to you for giving us the opportunity to do so, as well as sharing our enthusiasm for your article with you here this evening. And of course, to our thanks to you for being able to find the time in the middle of the night to be able to join us and talk to us. Clearly, this topic is one of huge and momentous importance at the moment, and is going to be one on which many people will be wanting to think and reflect both now and into the future about what this means for the future of our international order and the role that the General Assembly and the United Nations, indeed more generally, can play within it in relation to situations of atrocity crimes. And so this, I think, is hugely timely work, and it's a privilege to speak to you this evening, and of course a privilege for the ICLQ to be the place that can publish your work on this. So thank you very much indeed for sharing this with us this evening.
Well, thank you so much for having me. It's been a real pleasure.
Thank you very much, Rebecca. And now it seems strange when is looking to turn, should we say, I'm sorry, I know I'm looking at the screen rather than the camera. It's one of these tricks I've never got quite used to. But we now, I would say, change our focus of attention from the early career prize to our prize-winning lecture for this evening. And at this point, I'm sort of used to saying that we would turn to the room, but we're not turning to the room. We are, in a sense, turning partly to the room, but also back from whence we came, to Michelle Rourke, who is also in Australia, in Brisbane at the moment, I believe, and so equally early in the morning. But you and Mark are going to talk to us a version of your article published, which was the arguments against the inequitable distribution of vaccines using the access and benefit sharing transaction, which on the face of it might seem, well, what does that title mean? We will hear more about it, but it is instantly recognizable to us as addressing one of the, let me call it, other key pressing concerns that is facing the global community at the moment. How we handle pandemics, how we share the fight against pandemics, and how we, and so both our papers this evening really address in different ways the two most pressing issues on the global agenda at the moment. And I think it's really important that we recognize that. So without any more ado for me, I will pass the floor immediately over to Michelle, who I think is going to start us off for about 20 minutes or so before we pass the baton in the room to Mark. So Michelle, the floor is yours, and you are very, very welcome.
Thank you so much, and thank you to the British Institute of International and Comparative Law for having us tonight. And thank you to Malcolm Evans for introducing us and having us here. We really appreciate the opportunity to talk about our paper. So today I'm speaking to you from Brisbane in Australia. So I'd like to begin by acknowledging the traditional custodians of the land from which I'm speaking. So it's the Yagara and Turrbal peoples. And I just want to acknowledge that sovereignty over this land was never ceded. So for the lecture today, we've been asked to present our paper, Arguments Against the Inequitable Distribution of Vaccines Using Access and Benefit Sharing Transaction. And I think just about everyone on some level is pretty happy to agree with the statement that they are against the inequitable distribution of vaccines. It's just determining what equitable means and how we achieve it. That's where we sort of come unstuck. Mark and I want to argue something a bit more specific, and that is that access and benefit sharing is not ever the appropriate mechanism to distribute vaccines, no matter how you want to interpret the term equitable. As you would have noticed, vaccine distribution has rightly been getting a lot of attention lately, but this particular issue about vaccine distribution using the access and benefit sharing transaction, this issue rarely gets much attention from scholars, and we think that this might be because it encompasses way too many facets of virology, epidemiology, global health governance, and international law. So it's quite complicated. I'm a lapsed virologist who researches access and benefit sharing, and Mark is an international law scholar specialising in global health law. And we're both interested in and had published on this topic independently before we found each other's work and started collaborating. And that's when we were really able to start to dig into and address this issue more comprehensively. And we can't stress how important this issue is, particularly as the little attention that access and benefit sharing, particularly at the World Health Organization, does get in the literature is very often, we think, unjustifiably laudatory. So at the moment, the World Health Organization and its member states are starting to actively pursue a pandemic treaty, and that will likely contain elements of access and benefit sharing intended to overcome the vast global inequality we've seen and continue to see in access to vaccines for COVID-19. So today's lecture will require some background before we start making our arguments about access and benefit sharing. I'll start with some of the science and get into the origins of this policy called access and benefit sharing, which has its origins in international environmental law. And I'll tell you about how the WHO, the World Health Organization, has already borrowed this policy from environmental law for vaccine distribution through an international instrument called the Pandemic Influenza Preparedness Framework, or the Pip Framework. Once I've laid out this background, I'll pass to Dr. Eccleston-Turner, and he'll outline our arguments against the inequitable distribution of vaccines using the access and benefit sharing transaction by addressing the complexities of the law and the misguided logic of framing everything as a transaction. Okay, so until recently, whenever I was speaking to an audience of mostly legal professionals, I never assumed any level of knowledge about viruses, but that changed a couple of years ago. Everyone's had a massive crash course now. I know many of you would be familiar about the ins and outs of viral evolution, having experienced the coming and going of multiple coronavirus variants over the last couple of years. But this sort of evolutionary behavior has a lot to do with virus structure. So the coronavirus that we're all now quite familiar with has a single strand of genetic material, and it's a sister molecule to DNA. It's called RNA. And these viruses replicate within their host organism, so in this case, us. As they do that, they accumulate mutations, some of which can be advantageous to the virus. And prior to this coronavirus pandemic, the virus that got the most attention due to its pandemic potential was influenza virus. It has 8 strands of RNA, and those strands can slowly accumulate mutations the way that the RNA in coronaviruses can. This is called antigenic drift, and it's responsible for the changing strains of seasonal influenza that we see each year. But if 2 different influenza viruses are infecting the same host cell in humans, but it could also be pigs or birds, these strands of RNA, the 8 strands, can swap around. So you have an influenza virus packaging up the genes of an entirely different type of influenza virus. And this process is called antigenic shift, and it can be responsible for pandemic influenza strains. And I no longer need to spell out the potential consequences of a major pandemic, unfortunately. This all means that the seasonal influenza vaccines need to be updated with new strains every single year. And it also means that the global health community needs to be aware of any new strains of potentially pandemic influenza that might be circulating in human and also animal populations. And to do this, you need access to virus samples, and there's a global infrastructure that has been set up to ensure just that. The first influenza vaccines were developed by scientists in the US throughout World War II. Shortly after, in the 1950s, a group of 26 laboratories around the world joined together to characterize influenza virus strains and to monitor influenza virus evolution under the auspices of the then newly formed World Health Organization. And since then, the WHO has been using the data generated by this growing network of laboratories to make recommendations about what strain of influenza viruses should be included in the following year's seasonal influenza vaccine. Today, this infrastructure is now known as the Global Influenza Surveillance and Response System. It's grown to include 148 national influenza centres that they're spread in different countries all around the world. And there are 7 collaborating centres, which are hubs, and they all share viruses with each other. And they had done so on a largely informal basis. That was until 2006, when the Indonesian health minister said that they would no longer be sharing samples with the WHO's lab network because Indonesia had sovereign rights over those virus samples under the Convention on Biological Diversity. And they were essentially found to be correct. They do have sovereign rights over their pathogens or disease-causing agents. The Convention on Biological Diversity came out of the Rio Earth Summit in 1992. It's also where we see the deforestation and also, yes, a couple of other environmental treaties have come out of the Rio Earth Summit in 1992. The Convention on Biological Diversity has near universal acceptance with 196 parties, and that we have the notable exception of the United States. The CBD outlines 3 key objectives. So that's the conservation of biological diversity, the sustainable use of its components, and the fair and equitable sharing of benefits arising out of the utilisation of genetic resources. And it's this 3rd objective that creates the mechanism that we're focusing on today, access and benefit sharing. And that's just short for access to genetic resources and the sharing of benefits associated with their use in research and development. Viruses, as we just covered, are genetic resources. They are used in public health research and also the development of vaccines, and should therefore, generally speaking, incorporate the sharing of associated benefits. Indonesia argued in 2006 and 2007 that they were providing influenza viruses to the WHO's network of influenza surveillance laboratories, that their samples were being shared with other labs and even pharmaceutical companies without their prior informed consent. And their genetic resources were being used to make vaccines and diagnostics that were either not offered for sale in their country or were offered at unaffordable prices. This was not, to their mind, fair and equitable benefit sharing as required by the Convention on Biological Diversity. Indonesia's argument precipitated the adoption of the Pandemic Influenza Preparedness Framework, or the Pip Framework, by the World Health Organization in 2011. And this is essentially an access and benefit sharing instrument for that really tiny subset of viruses that can cause pandemic influenza. It doesn't even apply to seasonal influenza viruses that can cause around 500,000 deaths per year. The PIP framework, the Pandemic Influenza Preparedness Framework, also recognises the sovereign rights of states over their biological resources. It's a non-binding instrument adopted as a resolution of the World Health Assembly, and it's operationalised using Standard Material Transfer Agreements, or SMTAs. So this is why the PIP framework has received quite a lot of praise as a novel international instrument. It turns those non-binding provisions into the binding terms of standard contracts, and then those contracts can be used to commit private entities like pharmaceutical companies. There's the first Standard Material Transfer Agreement, that's between the National Influenza Centre providing the influenza samples and those are provided to the WHO. So that's the first agreement, National Influenza Centre and WHO. And then there's the second material transfer agreement between the WHO and the third party entity wishing to access influenza virus samples from the World Health Organization's Global Influenza Surveillance and Response System. So this is used to commit third parties, including pharmaceutical companies, to providing benefits during an influenza pandemic. And those benefits can include, but aren't limited to, diagnostic kits and vaccine doses. So this is the access and benefit sharing mechanism transplanted from environmental law, where benefits were supposed to be channeled into environmental conservation, into global health law. And it was done to deal with public health issues. And these are fundamentally different issues to the environmental conservation issues that it was originally designed to address. So as Mark will talk about shortly, we feel that this is not an appropriate method to tackle these issues. Many scholars argue that it actually hasn't even been a particularly effective method in international environmental law, the sphere in which it was designed. So why should any of this matter today while we're still in the midst of the COVID-19 pandemic? As I mentioned, the Pip Framework only applies to influenza viruses with human pandemic potential. That means that all other viruses, including seasonal influenza viruses, are covered by the CBD and its Nagoya Protocol by default. So the SARS-CoV-2 virus, the virus that causes COVID-19, that's not included in the Pip Framework, but by default, it sits under the remit of the CBD and Nagoya Protocol. Now, the Nagoya Protocol is something I haven't mentioned yet. It was adopted in 2010, and it just fleshes out the access and benefit sharing details that are found in Article 15 of the Convention on Biological Diversity. This means that if countries so choose, they can implement ABS, so access and benefit sharing, legislative, administrative, or policy measures governing access to their pathogen samples and the sharing of benefits associated with their use. The concern here is that access and benefit sharing is a hindrance to accessing pathogen samples in a timely manner. And this is particularly important during infectious disease emergencies. There are multiple examples of access and benefit sharing being a hindrance in some form or another in the past, and you can read about some of the confusion surrounding access to the Middle East respiratory syndrome coronavirus in 2012, also the Zika and Ebola virus samples. That's in our International and Comparative Law Quarterly paper. In 2020, China did share data on SARS-CoV-2, not always in a particularly forthright manner, but it did share data. It did not, however, share any samples. As it stands, there's no obligation under international law for countries to share samples. Article 15 of the Convention on Biological Diversity says that parties shall endeavour to create conditions to facilitate access to genetic resources for environmentally sound purposes. But that's as strong as the language gets there, shall endeavour. The Nagoya Protocol acknowledges that public health emergencies may require expeditious access to genetic resources, but it also says that there should be expeditious benefit sharing. So the closest thing in international law to an obligation to share samples is found in Article 6 of the revised International Health Regulations of 2005. And this only requires the sharing of public health information and not the sharing of samples. So now the World Health Organization is looking for ways to commit countries to sharing their samples and associated data in the future. And due to the supposed success of the Pip framework, there are now suggestions from a variety of parties that access and benefit sharing measures like those found in the Pip framework should be incorporated into the pandemic treaty that is currently being negotiated. A lot of countries from the global south see access and benefit sharing as an acceptable approach because it promises to deliver benefits, including vaccines, during the next pandemic. But the Pip framework hasn't been tested. It has not been tested during an influenza pandemic. And in research that Mark and I have published in the last few years, it's evident that the Pip framework has many conceptual flaws and legal loopholes, and we're not confident that it will be able to deliver these promised benefits during an influenza pandemic. Our concerns are also anecdotally supported by the vaccine nationalism of rich countries during the COVID-19 pandemic. So I'll now pass to Dr. Mark Eccleston-Turner to delve into some of the reasons outlined in our paper as to why we think the access and benefit sharing transaction should not be incorporated into the proposed pandemic treaty or any other future arrangements for securing either pathogen samples for scientists or diagnostics and vaccines for countries of the Global South. Thank you.
So thank you very much. And thanks, Michelle. You can go back to sleep if you need to. So what we've set up quite clearly here is that pathogen sharing, either via the Pip framework, the CBD or Nagoya, is a transaction. It's the exchange of a pathogen in exchange for something else. Put simply, these transactional approaches encourage developing countries to use their genetic resources as bargaining chips to try and secure enhanced access to diagnostics, treatments, and vaccines. And the mediating role that WHO has in this is intended to deliver a more equitable solution that doesn't just benefit the country of origin or the party access in the pathogen sample, but wider society. And on the surface of it, this may sound like a good idea, a win-win. But the ABS transaction applied to pathogen samples at all introduces a market-based solution to what is two previously separate problems. The first one, the need for public health researchers to promptly access scientific information and pathogen samples. And the second, that there is a scarce availability of vaccines and other medical countermeasures during a pandemic, and that rich countries hoard those to their own benefits and to the detriment of much of the Global South. And in our paper, we argue that a market-based solution, which is what ABS is, and a market-based solution that was designed to address biodiversity loss is not the right approach to addressing a global health problem. And that linking these two public health issues together solves neither problems. And it's important that we set out right from the start that ABS was never just about biodiversity conservation. It was also supposed to deliver fairness, equity, and justice, and redress some historic injustices, particularly in post-colonial settings. And historically, botanists and natural scientists would travel from the global north to the global south and extract biological resources, plants, animal species, without seeking permission either from the local community or national governments. They essentially saw biological resources of the global south as public goods, but only public goods for them. And these biological resources were expropriated to the global north, where they're used in a range of applications, right? From medicine to a beautiful thing to have in your home. Such applications, then they got treated as public goods in the global north. And the exploitative practice continues to this day when it comes to pathogens. There are very clear recent examples of exploitation in public health with pathogens, from H5N1, Ebola in West Africa, Zika, and MERS. And we don't seek to downplay or minimize this exploitation of marginalized people at all. But ABS and the access and benefit sharing transaction has done little to achieve the goals in biological biodiversity conservation, sustainable use, and fair and equitable benefit sharing in environmental law. And in many ways, that cannot therefore work in a public health setting. And the ABS transaction in the CBD was a compromise that was supposed to ensure that access to genetic resources occurred using the favored market mechanism of the time, trading sovereignty for access to genetic resources. And our concern is that ABS in the field of public health doesn't solve these problems at all. And we're increasingly alarmed by the continued push towards ABS in public health, where the incentives and the goals are very different from those in environmental conservation. And at the moment, the World Health Organization is engaging in a process of researching pathogen sharing practices and trying to understand the impact that the CBD and Nagoya is actually having on on the sharing of pathogens around the world. That's an ongoing process that started way back in 2018, when only a small number of us actually cared about the sharing of pathogens around the world. And there have been discussions, as Michelle outlined, in WHO and elsewhere about extending this ABS model to include other pathogens and using the Pip Framework as a model for multilateral ABS. And we think this is a bad idea for a whole host of reasons, some of which I'm going to outline here. And it's important to stress that whether bilateral or multilateral, pathogen ABS is a transaction. The access part refers to access to sovereign pathogen samples and genetic sequence information by users. And the benefit sharing is about providing private goods in exchange for those, such as vaccines and diagnostics. It's a quid pro quo. It's one thing in exchange for something else. However, bilateral pathogen ABS using the CBD and Nagoya means that benefits will accrue to those who are best placed to negotiate those benefits and not to those people who need them the most. And whilst multilateral ABS, pathogen ABS through WHO might be better equipped at pooling together benefits to distribute them to the nations that are most in need during an infectious disease outbreak, it's always going to be vulnerable to nations acting outside of the multilateral arrangements and engaging in bilateral access and benefit sharing arrangements, which may be more beneficial to the country in question, but much worse for the world as a whole. So one problem we have here is that the ABS transaction pits parties against each other in a buyer and seller paradigm who have opposing incentives. Providers and users of pathogens have some common interest, such as reducing transactional costs, but there are much stronger opposing interests here. Each stakeholder is looking to maximize their gains and minimize their costs in this transaction. Providers of pathogen samples want to maximize benefit sharing. Users want to minimize it. The Pip Framework was meant to ensure that this transaction was more effectively brokered by the WHO for a very small set of influenza viruses that Michelle just outlined. And in a multilateral ABS transaction with an intermediary party like WHO, the system is most attractive for providers of sovereign genetic resources if they can maximize the likelihood that any benefits which accrue will accrue to them specifically. For users, the multilateral system is most attractive if all providers are using it and nobody is prepared to provide similar genetic resources outside of that trading system. Providers, therefore, would prefer strong monitoring, compliance, and enforcement, and users would likely prefer the opposite. The multilateral mechanism is a less direct transaction, but it is still a transaction, and opposing market incentives and dynamics are still at play here. The second key problem we have is that WHO is a public health organization. It's not a financial clearinghouse. It can only be seen to provide benefits from a multilateral system in a way that accords with public health need. But for a multilateral ABS system to work, providers need incentives and rewards to actually provide pathogens, and incentives and rewards which accumulate to them and them alone. Otherwise, we encounter the free rider problem here. Why would any country agree to provide vaccines into a multilateral trading system if they think that benefits will never accrue to them? They want benefits in exchange for the act of sharing their sovereign genetic resources, but the WHO can only promise the possibility of benefits in the future, not a one-to-one exchange of access to pathogens in exchange for vaccines or medical countermeasures. This link between the act of providing access to the sharing of benefits is too weak to discourage free riding. And countries can simply elect to not provide any influenza samples to the framework at present, and they can still expect to receive benefits if their country has a strong need in a public health emergency. This destroys any incentive that would be required to encourage countries to continue to provide samples into this system. And the system is already being undermined by bilateral access and benefit sharing agreements, which are allowed under the CBD. That effectively cuts WHO out of the system and removes a middleman. Another issue is that WHO and other ABS forums are currently dealing with the problem of digital sequence information, or DSI. Now, digital sequence information is essentially the genetic code of a pathogen, which can be extracted from the from a pathogen, turned into a series of numbers or letter codes, and uploaded onto public forums very quickly. This is what China elected to share in the early stages of the COVID-19 pandemic. They shared the genetic sequence code digitally online. They did not share the physical sample. And we have the open availability of genetic sequence data on repositories like GenBank. And this completely undermines the market-based incentives which are inherent in the ABS transaction. For some applications, users may decide that accessing genetic sequence data is sufficient for their purposes, and they may therefore not require a pathogen at all, and they therefore do not need to engage in an ABS transaction. Whilst this information is publicly available to researchers openly online around the world at any moment, they can bypass engaging in access and benefit sharing agreements with the host country. They can just rely on the data itself. And provider countries may be less likely to cooperate with any multilateral system if they can see that it's already being undermined by online genetic sequence data, which is currently happening at present. Another issue is that by creating a market for human pathogens, which is what the ABS transaction does, we therefore introduce the market forces of supply and demand. Some viruses will be common and easily available. Their value in the ABS transaction will be negligible or minimal at best. Some viruses will be rare, very difficult to access, and their value will therefore be comparatively large. This scarcity can therefore make a pathogen valuable in ABS terms. And that scarcity, that value, is predicated on the pathogen being contained to one or maybe two countries within the sovereign territory of a small number of nations. And in such instances, there are very limited options for getting access to that pathogen if you require it. You will therefore be required to negotiate with the one or maybe two countries that actually have access to these physical samples right now. And the negotiating country will find themselves in a very strong position to negotiate a favorable deal for themselves. However, it's a truism of public health that infectious diseases do not respect international borders. And the moment a pathogen crosses from being contained in this one very small country or into this very small number of countries and begins to spread as viruses tend to do, the negotiating position with which the originating state finds themselves is significantly damaged or maybe wholly eroded. And this recently occurred with Zika. When Zika hit Brazil in 2015, European and US researchers were mainly working on samples from the 1970s of Zika. We identified a very novel strain, which was first identified in Brazil in 2015. And therefore, European researchers and researchers in the US sought to get access to these new samples from Brazil. And reportedly, the major reason for Brazil not sharing these samples rapidly was their access and benefit sharing legislation, which had created considerable confusion about how and when samples can be exported and shared. At this point, Brazilian lawyers began to negotiate terms for access and the use of their samples with US government representatives from the Centers of Disease Control. Interestingly, the Centers of Disease Control was the laboratory which was passing samples of H5N1 from Indonesia to pharmaceutical labs. And at the time this negotiation was ongoing, and at the time it looked like Brazil might be able to negotiate itself a very good deal. Zika was in very high demand. We were very concerned about its potential to become a public health emergency. Therefore, all the cards were essentially held by Brazil. At that point, Zika spread, and it spread into Puerto Rico and another US territory. And as such, the US Centers of Disease Control could obtain Zika samples from Puerto Rico directly without requiring an ABS agreement to be put in place. And at that point, Brazil got nothing. So this is a winner takes it all strategy. You either get everything or you get nothing here. The Brazilian government found out the hard way that your bargaining position very soon disappeared as soon as a disease spread and researchers can find alternative sources for their pathogens. Such are the dangers of pursuing bilateral ABS during a public health emergency. The desire of provider governments to secure benefits that maximize the protection of their population by being able to leverage one of the few bargaining chips which they actually have to themselves can backfire, leaving vulnerable populations even more vulnerable. And when viewed through the lens of an ABS transaction, quite perversely, the most valuable pathogens are the ones which are rare and stand to threaten the lives of the most number of people. This does not sound like a system that we want to incentivize the hoarding of pathogens of. This is perverse, and supply and demand dynamics can undermine the delivery of fair and equitable outcomes, as was seen with Zika in Brazil. And it's quite clear that when we look at the current COVID-19 pandemic, there was a very brief moment, a very, very brief window where the pathogen was quite clearly deadly, quite clearly had human pandemic potential, and was contained exclusively within the territorial borders of China. At that point, and at that point alone, China had the potential to negotiate themselves a very, very lucrative access and benefit sharing arrangement. As soon as international spread occurred, which occurred very, very quickly, that negotiating position disappeared entirely, because now China would no longer be negotiating its position against the CDC or against a private vaccine manufacturer. They would be negotiating that position against Australia, who had cases, the Philippines, who had cases, Indonesia, and it spread and spread and spread and spread and spread. So because of this problem, there is a desire to come up with a multilateral solution. But as we've already outlined, multilateral is vulnerable to being undermined by provider parties that are willing to circumnavigate the multilateral system if it stands to give them a better chance of accruing maximum benefits and therefore protecting their populations. And we think that WHO acting as a transactional clearinghouse, connecting the provision of viruses to the provision of scarce vaccines during a pandemic is a folly, and it's potentially a very, very dangerous one. And when we consider that ABS transactions is being framed as a way of protecting developing countries from infectious diseases, then we become all the more concerned. The ABS transaction creates a situation where only one country gets benefits that might more effectively be distributed elsewhere, if we're talking about a bilateral agreement. Or the ABS negotiations can be openly threatened by the open availability of genetic sequence information or the spread of pathogens to other nations, diluting incentives to share benefits. And on the other hand, when we have a multilateral system managed by the WHO, which can more effectively accrue benefits, it can only share them on an as-needs basis, not in a manner that actually encourages the sharing of pathogens by parties. Such are the dangers of pitting stakeholders as buyers and sellers in an ABS transaction and creating a market environment where individualism and cooperation and competition are valued over cooperation. And in a public health emergency, as we've seen, cooperation is really hard to come by, but it's absolutely key to tackle in a pandemic. The last thing we need is yet another system that codifies and enhances the incentives for individualism over cooperation. And the ABS system is often argued as being mutually beneficial, right? Everyone wins under this system. And this concept is present throughout the language of the CBD and Nagoya, but there are major power differentiations at play here between buyers and sellers, users and providers. Developing countries, which is where most emerging infectious diseases emerge from, are not often in a position to turn down a deal that are seemingly beneficial in the short term, but do not benefit them in the long term. Meanwhile, developed nations and their industries are often in a much better position to make long-term strategic moves that work in their long-term interests. And at the end of the day, framing the sharing of data and information and engaging in collaborative research where provider nations as benefits, benefits are provided through an ABS transaction is fundamentally unfair. Framing ABS is like saying that provider countries only deserve these benefits if they first purchase them with their genetic resources. We honestly view these sorts of Oh, and unlike most other physical resources, culturable pathogen samples can be non-exhaustive and their use non-exclusive. Some pathogens can be grown and replicated to the point where an infinite number of replicate samples exist. In a sense, anyone can use a pathogen sample as desired without diminishing any of the amount that's left in the commons. Therefore, in a marketplace, pathogens might be more appropriately dealt with as information rather than a physical resource to which property rights are applied. But despite this, the current approach to pathogen access and benefit sharing treats pathogens as tangible assets that a state can exercise their sovereign rights over, something akin to a private property right, where the rights holders can exclude others from accessing or using those resources without prior informed consent. So I've just covered some of the reasons why the ABS transaction and this market-based solution may not be appropriate in the field of public health. These have all been quite technical issues about supply and demand and market-based incentives, but there's also a human rights argument to be made here. We go into this in a fair bit of detail in the paper, but ultimately, the framing of the issue of fair and equitable access to benefits, access to vaccines and other medical countermeasures within the ABS transaction reduces equitable access to vaccines to something that can be traded for if you're fortunate enough to hold a virus of value, rather than viewing equitable access to vaccines as an innate right, which all people have a claim to, regardless of how much their government happens to have engaged in the bilateral or multilateral trading of pathogens. Developing countries shouldn't have to purchase fairness. They shouldn't have to purchase equity using their sovereign resources. It really is quite that simple. The ABS transaction creates a framing or a norm that you are entitled or you are worthy of receiving vaccines because, and only because, you've engaged in a bilateral agreement here. And I think that really does distract from the normative basis, even if it's not a strong normative basis, that the human right to health includes access to essential medicines. That might not be a strong legal solution in this case, but we worry that framing these issues as transactional actually detracts away from that norm. And we think that that norm has value in a political sense, even if it doesn't necessarily have strong legal enforceability. And that's one of the things we worry about most with this push towards transactionalizing these issues, whether they're bilateral or multilateral. We think that we're moving further and further away from a rights-based approach to healthcare, particularly in low and middle income countries, where the benefits of scientific endeavors is something that can be traded for by low and middle income countries. And our biggest problem with Nagoya and ABS is that it's presented as a solution. We don't need to fix access to medicines because we have Nagoya. You can just use your pathogens as leverage to get those vaccines and those antivirals which you need. Whereas we don't actually have any examples in the history of this system existing, either in public health or really in environmental conservation, where low and middle income countries have successfully used their pathogens as or any of their sovereign resources to leverage an effective access and benefit sharing agreement. I can't think of a single example where a country's been able to do that. And in fact, the only examples we have are negative here, that this system doesn't work. But even if they were able to successfully do that, let's say Indonesia in 2007 was successfully able to negotiate a really good access and benefit sharing arrangement for itself during H5N1. Great, that's a good deal for Indonesia. Okay, what about Laos? What about Cambodia? What about Singapore next door? What about any other low and middle income country around the world, not just those that neighbor Indonesia? What about them? Because the ABS bilateral transaction is an all or nothing game. All of the benefits go to one country and the one country that can successfully negotiate this agreement in time. And even then, we don't have an example of this being successfully done. But even if we did, we'd end up in a situation where one country got everything and any other country who might have equal or greater need got nothing. And I think that we need to think more creatively about the solutions to these problems. And multilateral ABS is presented as if it is the global solution to these problems. But it has huge market inefficiencies, which don't solve equitable access issues at all and disincentivize pathogen sharing. And the ongoing pandemic, which we're living through right now, provides us with a really interesting example of why we need to rapidly share pathogens and associated data and distribute scarce vaccines during a pandemic, but not necessarily linking them together. Within COVID-19, there was no meaningful discussion about providing access to vaccines linked with the provision of samples. This could be for any number of reasons, all of which point to the fact that ABS transactions using pathogens can't work in a public health emergency, and a multilateral ABS system ought to be shelved. China released the genetic sequence for COVID very quickly, but they didn't share samples. And access to genetic and physical samples from other countries soon followed. By the time any source country had the chance to negotiate an access and benefit sharing agreement in the early stages of the pandemic, in the hope of potentially securing a good deal for them and their populations, by that point, the value of the sample was minimal, if not completely negligible, because it had spread to multiple countries by that point. This again highlights this key problem with applying ABS transactions in a public health space. The logic of access and benefit sharing can discourage the sharing of pathogens in the early days of an outbreak, where the provider country attempts to negotiate the best deal for themselves. This is precisely when the world needs access to pathogen samples for research and development. Transactional approaches are unfair and they're inefficient. This inefficiency exists on both sides of the arrangement. Access and benefit sharing arrangements slow down the sharing of pathogens with the wider international community, potentially harming our response to a future pandemic. And these systems are not able to ensure equitable access to vaccines in a pandemic, particularly in low and middle income countries. The previous failings of the ABS regime in Zika, Ebola, MERS, H5N1 that we cover in our paper indicate that a transaction of pathogen samples for medicines is not a fair and it's not an efficient approach for either access to samples or access to benefits from using that, from their usage. To sum up, whether it's multilateral or bilateral, ABS creates yet another space in which users and buyers are antagonists, both of whom wish to maximize their own gains. But this framing fundamentally ignores that there are mutual interests here. The whole point of the UN system is to encourage cooperations between nations who have sometimes disparate but often similar interests. Surely we can start to think outside of this market-based mechanism that have perpetuated these unfair dealings to the continued detriment of developing nations. There was and there remains a solid normative basis for the expectation that viruses should be shared for the sake of good public health. It's a norm that to some degree was thankfully upheld by China when it shared its genomic sequence of SARS in the very early days of the pandemic. On the one hand, our world is relying on this norm to be able to respond to the next pandemic, while on the other hand, it's actively undermining this norm with the application of ABS policies. This norm of openly sharing pathogens could and should be strengthened if developing countries were not made to feel that access and benefit sharing policies were their only opportunity to get access to vaccines in an infectious disease outbreak. We should be looking to develop solutions to these two issues in parallel, not in linking. Linking these two issues with a market-based mechanism guarantees that neither access to pathogens nor the sharing of benefits associated with their use will occur in a fair and equitable manner. Thank you.
Well, thank you very much, both of you, for the powerful presentation and the clarity of a powerful presentation that you gave of this complex matter. I'm going to open it up for questions now. We have one online too, and I would encourage anyone who is online who wishes to ask a question, please do so. But to get the ball rolling before I, having listened to you both this evening, will you forgive me for asking what perhaps is the idiot question? Why did anyone ever think this was a good idea?
So that really came about partly because of Indonesia's insistence that biological samples were their sovereign resources. But I think part of the reason for that is because actually in these circumstances, low and middle income countries have no other choice. This is their one bargaining chip. And I realize in our paper, we're essentially making the argument that bargaining chip needs to be removed. But the point which we're making is that it needs to be removed and replaced by a better solution. I think that the issue is that low and middle income countries have no other choice other than to barter away their sovereign resources. And it was a fudge which worked very, very nicely for lots of high income countries who get all of the benefits of this system. We get access to the samples which we need. We get the vaccines which we need developed using those samples. Stuff doesn't flow back to low and middle income. Well, oh well. And it's a system which we are quite happy with, and low and middle income countries don't really have any other choice. That's the situation. And our main issue is that this system is, rather than taking the view that you're taking, and hopefully the view that people have taken away from our talk, that actually this system is broken and we need to abandon this and start something new. We're pushing further and further ahead with this. You know, this is being embedded further and further in ideas like the pandemic treaty. Yeah, Michelle, what did you have any thoughts on that? You awake?
No, I think you're right. Yeah, I'm awake. I think you're exactly right. It was about the initial framing of the argument by Indonesia, and that set us down a path which we are still hurtling down. And I think there hasn't been a real effort to step back and reconsider what access and benefit sharing actually is. There's a lot of talk about equity and fairness. So it's got great branding, but it doesn't really deliver on that equity and fairness.
And I think there is a growing degree of skepticism among some low middle income countries about this system now. I think that they are starting to see that the emperor has new clothes, that they were sold something which really doesn't work for them, and we need to look at something different.
Please, yes.
Hi, Abiodun from Bickle, and if I could, Chair, I'd like to abuse our hosting privileges and ask 1.5 questions, if I may. So my first one is, casting the dial back 10 years ago, there were loads and loads of conversations about the trans-investment, Atlantic Partnership and whatnot, and loads of people were having discussions about how do we as individual citizens influence this big international organization and bilateral treaty conversation between nations. So in a field where the subjects are very much nation states, how do you see citizens' participation fitting within that? And then the second aspect was around, we just had the government tell us that, Lady Hallett's going to run an inquiry over COVID and whatnot. And in this organisation, we're considering how we contribute to that. And we're quite concerned that issues of this nature and issues of international law and even issues of the rule of law more generally are going to be absent in an inquiry where the discussion is around parties and, who was where, when, what happened and who knew what and what happened when and whose mate got the big contract for the kit. So I suppose how you think research organisations and academics can help to get these important issues up the agenda when I think there's going to be a focus on some things that perhaps don't matter as much in the grand scheme of things and certainly don't matter as much in the long term.
So I think those are both really good questions. I think one of the things that we can do as sort of in terms of advocacy or in terms of being academics is to think outside of the orthodoxy. This has very quickly become the orthodox view, right? That you will frame this as an ABS issue. We will have pathogen and benefit sharing, and one of the benefits which we can put forward is to provide alternatives. Shell and I have spent a long time thinking about this, and we're just trying to come to grips with what an alternative system could be that doesn't fall into these pitfalls, but having alternative suggestions on the table, I think would be a really, really good position to go through. And I think one of the things that we've got to start from the position is the fact that, the global health system is fundamentally broken. But the problem is it's broken in our favor, right? I benefit from how fundamentally broken this is and how in my advantage this system is. And it's very, very hard to get individual citizens to sacrifice something, right? Because you're asking us in this room to maybe not get vaccines as quickly next time, or maybe get as many vaccines in order that other people can benefit from them. That's a hard sell, but it's a really, really important one. And it's the fundamental question. But we've got to start from the position that this system doesn't work. But it works for us, but it doesn't work for society, and it doesn't work for some of the world's poorest people. And that's a really difficult thing to sell, but I'm interested in doing it.
Well, thank you for that. Another question in the room, and then I have one online, please.
Thank you. It's a very interesting presentation. I have a question that regards the sort of other side of the coin, in the sense of the scenario late last year where South Africa and Botswana shared openly data on the Omicron variants and not pursuing benefits, but rather just for the sake of science. And so instead what happened was punitive measures against South Africa, against other African countries. So you sort of have this scenario where there isn't a pursuit for benefit, because if you pursue benefits, it sort of discourages pathogen sharing, and you instead, but at the other end, you're now being punished for sharing that data. Do you think that this sort of politicization of viruses, this move, is going to not just it's going to push the way we share data in a different direction in the global south actually now being encouraged not to share this data?
Yeah, so that's a great question and a really good point, which is that we've created a perverse incentive here where we're actually encouraging countries to withhold data about their outbreaks in their countries, despite the fact that, Article 6 of the IHR says you need to share, share within 24 hours this information with WHO. But look at what happens when you do. Look at what happened to South Africa. South Africa, for the benefit of science, alerted the world to the fact that Omicron was a thing and how severe it was. And there was no support put in place for South Africa. There were no flow of resources into South Africa to help South Africa deal with this quite major outbreak, which they were going through. Rather, as you say, there were very heavy punitive measures of countries imposing very strict lockdown on South Africa and some of its neighboring countries as well. You then create a system where, why would you share? If you realize that an outbreak was happening within your territory, you've actually got incentives to not share that, because fundamentally, the system we've created is about making sure that low and middle income countries alert us in the global north to problems they have so that we can shut our borders, make vaccines and use them all on our own population, while providing no support and no incentive to those countries. So why would you share? And also, when we're thinking about the development of a new pandemic treaty, why would you go along with this? This idea of a new pandemic treaty is being pushed at WHO by the EU in particular, who were one of the worst offenders for vaccine nationalism and border closures. Why, if you're a low and middle income country, why would you look at this system and think, yeah, you did me all right last time, I'll see what you're going to do this time? You just wouldn't. We've created a really broken system. And yeah, we're creating incentives to hide these outbreaks, hide your data, hide your pathogens, because one, if you do openly share your data, you will have punitive measures imposed upon you. But number two, if you hold that virus for long enough, you might be able to negotiate a good deal for your people. Maybe the only good deal for your population that you might get. All the while, pathogen spreads and spreads and spreads. And actually you end up in a situation where you get no benefits accruing to you anyway, and you get your trade and travel restrictions imposed upon you. We need to start this system again because it's broken. And we need to look fundamentally at what this system is serving right now. Because we in this room, we benefit a lot from this system, but there are, billions of people living through this system who get no benefits from it, and only punitive outbreak, punitive responses and no medical countermeasures, no vaccines.
Might just add, sorry to interrupt. I might just add that the Pandemic Influenza Preparedness Framework has a partnership contribution as well. So I'll explain what that is. We didn't mention it in the talk. So on top of the specific benefits that, say, a pharmaceutical company might provide to the World Health Organization for distribution in a pandemic, the pharmaceutical companies also pay a partnership contribution, it's called, or like a fee to use the global influenza surveillance and response system and to receive those virus samples that they need to make vaccines. So what we've found in previous research is that the partnership contributions have been used. So we're talking about $28 million, I think. Mark, please correct me if you can remember the figure off the top of your head. So that's per year. And the way that's being spent is in lower and middle income countries is to set up an infrastructure so that they then have that data to share. So one thing that we should note about the South Africa situation is that it may not have been South Africa where Omicron originated, nor where it was located in isolation. It was just, that's where it was detected first. So there's a lot of money being put into the detection and the sharing of samples. But we sort of feel that while that's securing the access side of the access and benefit sharing transaction, it doesn't do anything to help secure the benefit sharing side of that transaction.
Thank you. If I could turn to a question that has come in online, I think that will be the penultimate question before I've just got one final one to put to you. And this is from Jack Cook, who starts off by congratulating you both for an amazing talk. And it was really just flagging up whether the problems of the Pip framework are simply very similar to the general problems of international dispute settlement, interstate dispute settlements, in the sense as you've just got the problem of inequality of bargaining power. And if what is really underpinning this is an inequality of bargaining power, is a pandemic treaty really likely to change things? Because ultimately enforcing a pandemic treaty is going to fall back on precisely the same mechanisms that reflect the same imbalances.
Yeah, and I think that's a really important point. And one of the things that we've been doing a bit of work with governments about this pandemic treaty, because we're quite skeptical about it. And one of the things that we keep asking is, what are you willing to sacrifice? You as a high income nation, what are you willing to sacrifice for the next pandemic to improve overall public health, to improve global health? And tends to be met with silence in the room, because they don't want anything. They don't want to make their negotiating position worse. I think the fundamental problem that Shell and I think about the Pip framework is that it gives a sense of false hope. That's our big fear here, is that low and middle income countries are counting on the Pip to deliver benefits during the next flu pandemic, and those benefits will never arrive, or they'll arrive far too late. And they're factoring into their pandemic preparedness plan that we will get X number of doses through the Pip framework, and that has been secured on behalf of our population. And our real concern is that it won't deliver. So our big fear with it is that it's a sense of false hope to low and middle income countries who think that this system has been fixed for them, or this system has been fixed through Pip, and extending this fix out to things like the pandemic treaty is the next logical step. Did you want to come in on that, Michelle?
Yeah, I just might mention that the inequality of bargaining power is being packaged up within the pandemic treaty as well. So I think as Western countries, we're all sitting back with our third vaccinations and saying, well, we're done with this pandemic now, more or less. So now we'll start negotiating a pandemic treaty. And then we're enforcing those negotiation processes on a lot of lower and middle income countries that don't have the resources to address the pandemic that's still ongoing. And they're instead being forced to reroute those resources into negotiating this pandemic treaty. So that's where all of the public health assets are going to be focused during that period. So I do think that the inequality of bargaining power will be an intrinsic part of that pandemic treaty.
Which I think goes back to the point we were making earlier, that fundamentally this system is broken, but it's broken in our favor, right?
Yes.
Okay. Final question then, one more has come in online, and I'll just link it with a final comment. In a way, these are sort of perhaps more forward-looking about what some of the solutions might be. One question Arjulinda has asked, do you see any role when thinking about solutions potentially for the WTO, for example? To which I would simply add alongside, from what you say, from listening to you, in a sense, part of the problem here is just going back to this idea that the samples amount to tangible assets subject to sovereignty, and perhaps a reconceptualization of that entire idea is what one needs to trace it back to, rather than the trade-offs. And if that's so, does the idea of the common heritage of mankind, which may seem an odd thing to apply in this instance, but nevertheless, there is a resonance with a global common, something which is of a fundamental value to humanity as a whole, which absolutely should not be subject to sovereign appropriation, but regulation and access for the benefit of all potentially offer a different conceptual lens?
Absolutely. And on that point, actually, Michelle and I have just finished a chapter on viewing pathogens as part of the common heritage of mankind in a book edited by Michelle, available in all good bookstores at some point soon. Small plug. Yeah, you know, I don't see a view for the WTO in this situation, or for you know, in going down the route of viewing these as private property rights. I do think that you're absolutely right that we need to move back to a situation where we view these as part of the common heritage of mankind, and just something that there is an open commons around. But crucially, we cannot move to that situation until we fix equitable access to vaccines. Because if we move to common heritage, we just then end up with a situation where low and middle income countries are expected to provide everything for us for the benefit of science, the benefit of humanity, but nothing comes back to them in return. So we need to fix that problem concurrently. And that's the very, very tricky bit at the moment. But we need to do it in a separate way. We cannot link together the provision of access of pathogens with the sharing of benefits. That ABS system, we need to break that system entirely and think about viruses as part of the common heritage of mankind, but also think about vaccines as something akin to a common heritage of mankind, or something for the common benefit of mankind, rather than being private goods which can be traded to the highest bidder.
Thank you.
Thank you very much.
Well, I think we've reached the end of our allotted time, so I think we must draw this to a close. I'm sure everyone in the room and online would like to join me in thanking everyone who has participated in this evening. Rebecca, Michelle, yourself, you know, for two sets of most stimulating talks on very different, you know, very different but related topics because of their extraordinary topicality and the challenges that they present to us all. As with all good lectures, there's an opportunity for a plug, which you perfectly got in about your forthcoming book. Let me give the plug for the ICLQ, but also in relation to these articles, both the articles that on which tonight's talks and presentations have been based will be made freely available online, so they're free to download for a given period of time through the ICLQ website. And of course, I would like to thank the Cambridge University Press, both for facilitating that and supporting the evening here, and of course Bickle, our hosts, for yet another hospitable evening, and the hospitality will roll over into some refreshments at the end. And just as I thank you, I just have to repeat one phrase that really resonated when he spoke, which I think is a good one for us all to go away on. In all walks of life, one shouldn't have to purchase fairness. And I thought that was a very, very powerful expression, and something that I think we would do all well to carry with us. So thank you very much, and thank you for participating tonight. Thank you for attending. Thank you wherever you are for attending, and we draw the evening to a close. Thank you.